I would advise you, as a practical matter, and I know you've been told this before, but be prepared for anything. It's usually not going to be the best response to say, that's an illegal question, you don't need to know that. I don't think I want to answer that question. Because if the person asking it asks you, then they don't think it's inappropriate. Now, it could objectively be inappropriate to ask you, but you should probably be prepared for anything. I said I wasn't going to give you many practical pointers, but I will give you the practical pointer, be prepared for anything. In my career of interviewing, certainly you all have a prepared response for what's your greatest weakness, and you probably have a response for what's your second greatest weakness. Well, I personally have been asked, what's your third greatest weakness? And I can tell you, I was not prepared. I didn't have 3 prepared, so I kind of stumbled through that. So obviously, be prepared for anything. So, as I said, no question is illegal per se. Discrimination is prohibited, and discrimination requires an adverse action. So be prepared for anything. Yes, sir.
Hi. Sorry, no, I forgot. Well, if you could ask a question like that, can you just say, can you tell me how is this relevant to the job?
I think so. I think it depends on your personality. You can ask them, gosh, I'd be happy to answer that, but why are you asking? What's that relevant to? Are you asking all candidates that? I was asked, speaking about myself again, I've been asked in an interview, do you believe that gay couples should be allowed to adopt children? Wow, that's kind of a hot button issue, and the problem was I knew that the person asking it must have a very strong opinion on that one way or the other, and I was not prepared, and I knew I'm dealing with someone who I better get it right according to his beliefs. I think it depends on your personality. I didn't handle it the best way. I honestly don't remember what I said. I just stumbled through it because I was so unprepared, and I was trying to, be diplomatic and kind of feel out where he was coming from. You can handle it how you want. You can't even refuse to answer if it's particularly sensitive or you don't want to share the information. But as I said, I think that if someone's asking it, they subjectively believe that it's important to them. So you refusing to answer.
That's why I asked, is it all right to ask, how is this relevant to the job? Because maybe they do have a valid business reason to ask that question. That's why I did. I guess it's my decision if I want to.
I think so. I think
answer
that's it. I think that's it. Yes, ma'am.
I can remember one of the weirdest questions I was asked during a phone interview was, what music did I want to hear when I walked into a building sometime? And I was kind of like, I did answer opera just because I thought I would be unique. So I was trying to do that. But there's a couple of companies now, healthcare companies in the St. Louis area that are now embracing no smoking. They won't hire anybody that smokes. I don't know how far that policy has gone. I mean, obviously there's a legitimate healthcare reason, that there's impact to the employer for a lot of things, lost days, all that fun stuff. But how far is that into discriminatory actions?
The reason that those healthcare providers were able to enact the "we won't hire anyone who smokes" is because those were religious-based healthcare providers, and religious-based organizations are not subject to the Missouri Human Rights Act. That's something else I should have said. So, Mercy Healthcare, I think one of the ones that actually did that was SSM, which is a religious-based organization. So the Missouri Human Rights Act doesn't apply. Now, there is a Missouri statute on point that says smokers can't be discriminated against for smoking and I think even drinking on their own time away from the job, okay? But an exception to that is religious-based organizations. So if you're going to a secular organization, a non-religious-based organization, they're not going to be able to get away with saying, we don't hire smokers. They can certainly, regulate not smoking, right? They have to regulate, at least in St. Louis County, you not smoking on the job or right outside the door. But they can't say, if you smoke on your own private time, we're not going to hire you. Yes, ma'am.
I think there's just kind of a thing here we need to understand. If you're getting questions in an interview that are very uncomfortable, that's an indicator that that culture is not something you really want to be involved with. And I realize that people need a job, that they're looking, they need to go to work. But once again, from an HR perspective, if those of you who know me, that I'm kind of tough love, okay? If I'm interviewing you and right off the bat, and I ask a question that probably I shouldn't, and you look at me and say, well, what does that have the relevance to do with this job? I'll go, well, thank you. I hope you have a real nice day. Okay? That interview is over with. You did not cooperate, okay? Now that sounds tacky on my part, but if you can come up with a way to segue away from something rather than just saying, no, I think that's an inappropriate and I'm not going to answer that. If you're really interested in working for that company, find a way to segue away from it without being a little obtuse about it, okay? But understand, if you are in an interview and you are getting signals that this company's interests and why they're asking a certain line of questions that are totally adverse to your beliefs and your value system, you don't belong there.
Good point. Let me run through quickly the procedures for bringing a claim of discrimination. I say for most claims, you have to file a charge of discrimination with either the Federal Equal Employment Opportunity Commission, the EEOC, or the Missouri Commission on Human Rights. I say for most claims. This would cover all the claims we talked about before in the protected classes. Okay, so you can't just run to a lawyer and file a lawsuit for race discrimination, sexual harassment, age discrimination. You have to file this administrative charge first. Now, why is this? Well, going back to the 60s again, when these laws were enacted, the EEOC was set up to be something of a gatekeeper to look at claims and figure out which ones had no merit at all and which ones could proceed. It also provided something of a cooling off period for the parties because a lot of times emotions run high in these situations. So this was a cooling off period and a way to kind of filter the potentially meritorious claims versus those that weren't. Nowadays, my experience is the EEOC certainly represents a cool down period, but there's no filtering involved. You're going to eventually get your right to sue notice. So if you file a charge with the EEOC, undoubtedly, unless you're claiming something that they don't have jurisdiction over, such as I was discriminated based on my age and I'm 35 years old, well then they're going to dismiss it because that's not protected. But as long as you're filing a charge with them that on paper, states a claim, they're going to give you a right to sue. You have 180 days from your rejection. Let's stay in the application scenario, from your rejection of an application to file your charge with the Missouri Commission on Human Rights. And you have 300 days to file it with the EEOC. Now, these days, you're going to want to make sure you stick to that 180 days. That sounds like a long time, and it is 6 months, so you have plenty of time. Relatively speaking, though, in the context of statutes of limitations, it's very fast because there's some claims with the statute of limitations of a year. Those are rare. Usually you're dealing with 2, 3, 5 or 10 years. Most statute of limitations, I would say, are 5 years. So talking about 180 days in the legal context is very quick. Now, there's a number of reasons why you want to make sure you comply with that 180 days and file with the state agency rather than just the federal agency. There's no cap on damages in state court, but there is in federal court. As I said earlier, the Missouri Commission on Human Rights applies to employers which are 6 employees. You don't have to reach that 15 that you apply. The standard to prove your case is easier, the causation standard. And I'll touch on that in a moment. Now we're getting a little legal, but the issue in these cases is, was the illegal trait, let's say your age, was the fact that you're over 40 a motivating factor or a contributing factor for you're not getting the job offer? The motivating factor is the federal standard. The contributing factor is the state standard. So it doesn't have to be the only reason, okay? There could have been legitimate business reasons that contributed to you not getting the job. But as long as your age was a tiny part of that, that's all the standard that needs to be proved. So it's a rather plaintiff-friendly standard. It slants towards the individual. Now, a few months ago, the Missouri legislature passed a bill that went up to Governor Nixon to change that to make the contributing factor conform with the motivating factor standard. That is, make it a little harder for plaintiffs to prove their case. And not only did Governor Nixon say no, he said a resounding no. This is the state of the law. The Missouri legislature tried to change it to get in line with federal standards, and the governor said absolutely not. The damages. The damages under the law are going to depend on something you're going to be want to be doing anyway, that is continuing to apply for jobs and find another position. Okay, so you can't just kick back and say I was discriminated against. I'm on easy street now. My damages theoretically are racking up, and I'm going to stop my job search efforts, because you have what the law calls a duty to mitigate. That is a duty to mitigate your damages by continuing to use your good efforts to find another job, and hopefully you will, to cut off those damages. So for instance, if you were applying for a job in which you would have been making $50,000 a year, and you didn't get that, and let's say you didn't get it for some illegal reason because your age was a factor in not getting that job offer, you can't just kick back and say, you know, I'm basically making a salary of $50,000, and you know, when the jury comes back, I'll get that. You need to continue looking for a job, and if next week, if the week after that, you've got a job paying $50,000 or more, and held on to that, well, then your damages would only be about $1,000, economically speaking, because you would have a week of damages there. But it's not just economic damages. There's also, in this law, this phrase has perhaps negative connotations, but emotional distress damages. Emotional distress damages don't have to be, these days, they don't have to be that you receive medical treatment or with the therapy because this happened to you. It can basically just be what the Missouri courts call garden variety emotional distress damages. That is, obviously you're going to be upset. It's not a pleasant thing to not get a job offer. Certainly not a pleasant thing to not get a job offer because you believe it was because of some illegal reason. And the law recognizes that, and you can recover damages to compensate you for that emotional distress that caused. There's also punitive damages available under the law, and these all depend on what the judge and the jury allow.